and welcome to the fourth video of your course on legal research. We're going to learn about judgments or case law and how to use them to prepare arguments in a legal research task. Have you ever heard of Donoghue versus Stevenson? It's a very famous case that almost every law student in the English common law world studies, not just in the UK, but also India, Australia, and Canada. And it still forms the basis of the contemporary formulation of the law of negligence. In this 1932 judgment, the House of Lords developed a new formulation of the law from general principles and observations about the way in which the law has already developed up to that point. So if you haven't read it, the text of the judgment is also available online, and it's important that you read this judgment before you proceed further with this video. The reason that we are insisting that you read it is because apart from its position of significance in common law, it is also an excellent example of the various ways you can use case law in your legal arguments. We also recommend that you print and keep a copy of it with you as we go through this video. So Donoghue versus Stevenson is the famous case of the lady whose friend bought her a bottle of ginger beer. In those days, ginger beer was sold in ceramic bottles, so you couldn't see the contents of the bottle before opening it. On opening it and pouring its contents out into a glass, the lady discovered a decomposed snail and fell ill afterwards. The action that was brought before the court was against the manufacturer of the ginger beer, alleging that he did not take proper care in ensuring that the contents of the bottle were safe for consumption. Lord Atkin, at the beginning of the judgment, said that the question before the House of Lords was a purely legal one. I quote, "The sole question for determination in this case is legal. Do the averments made by the pursuer in her pleadings, if true, disclose a cause of action?" So he's telling the reader what the entire judgment is going to be about. The determination of whether there is a cause of action available to the lady who bought the contaminated ginger beer. He goes on to say, "I do not think a more important problem has occupied your lordships in your judicial capacity." Here, he's addressing the other members of the court. They're important, he says, both because of its bearing on public health and because of the practical test which it applies to the system under which it arises. That second part really tells you why we are reading this judgment in this video. Lord Atkin has already recognized right at the outset that he is looking closely at this particular area of law and looking for developments in it. So he goes on to talk about the current law and outline the legal issues in this case, where he says, "We are solely concerned with the question whether, as a matter of law in the circumstances alleged, the defendant owed any duty to the pursuer to take care. Did the manufacturer of a bottle of ginger beer owe a duty of care to Miss Donoghue, the consumer of the bottle?" He observes that at the time in the English and Scottish law, there was no general observation that had been made about the duty of care and the kinds of relationships that would give rise to a duty of care. It is remarkable, he says, how difficult it is to find in the English authorities statements of general application defining the relations between parties that give rise to duty. So he goes on and looks at some of the cases where there have been relationships noted, but none of those cases gave a general statement or a statement of general application that can be applied usefully in the future. The only case that existed at the time that Miss Donoghue came to court, with the case about the snail in the ginger beer bottle, were ones where particular duties were already established in specific situations. For example, the relationship between an employer and an employee would give rise to a duty. No case had yet established that a manufacturer owed a duty to someone who eventually consumed their product. This was a problem for Lord Atkin, but what is interesting is that he took that particular problem and said, "And yet the duty which is common to all of the cases," that is, all of the cases that already existed at the time, "where liability is established, must logically be based upon some element common to the cases where it is found to exist." So what he's saying is that if all of these different cases recognize a duty, there must be some common element there. And as you may know, his judgment in this case went on to find and develop that common element. And that common element went on to become the foundation of the law of negligence as we know it today. Importantly, he noted that such a general duty must be based upon a general public sentiment of moral wrongdoing for which the offender must pay. And that's how he introduced some ideas of public policy. The judgment then goes on to review one of the arguments in the case that was put before the Lords, which was about this concept of neighbor or proximity. So in response to the question of to whom do you owe a duty, there were some cases about owing a duty to someone who is your neighbor. Now, this neighbor was not necessarily the actual person that lived next door to you, but people that you came into contact with in your everyday life, people that you have a proximate relationship with. And after reviewing those cases, he looked at how that particular doctrine of law has been applied and the arguments that were before him in this case. The argument was made that this neighbor principle did not apply in this case. Lord Atkin, however, turns the argument the other way around, and he says if this were the result of the authorities placed before him, he would consider such a result a grave defect in the law, and I quote, "So contrary to principle that I should hesitate long before following any decision to that effect which had not the authority of this House. I would point out that in the assumed state of the authorities, not only would the consumer have no remedy against the manufacturer, he would have none against anyone else." He gives a host of other practical examples, and then he concludes that part of the judgment by saying he does not believe that the principle of common law was so remote from the, and I quote, "ordinary needs of civilized society and the ordinary claims it makes upon its members as to deny a legal remedy when there is so obviously a social wrong." Now, these are all methods that you can bring into your case law research and legal arguments. You can identify and analyze the present state of the law using case law. That much is not difficult to understand. But remember that you can also do what Lord Atkin did and bring in considerations of public policy and observations about the need for legal remedies in some contexts. In the next part of the judgment, he goes through a series of authorities. He has conducted his own legal research, as he says in the judgment, and he first goes through the authorities that support the proposition that there should be a duty of care between the manufacturer and the consumer, and later that there should be a general duty of care developed from these principles. He reviewed the basic facts of those cases and the reasons for the judges making those decisions in support of the principle that he's trying to put forth. This is how he marshals the support of these judgments. He then goes to the other side. He looks at the cases which do not support the argument that he's trying to make. This is an important step that we need to take note of and incorporate into our legal research. Don't just go through the cases that support our argument. Make sure that you also deal with the cases that might be used against your argument. Now, while Lord Atkin uses a variety of methods to dismiss these cases that do not support his argument, there are two main ones. The first is to look at the facts of a case and distinguish them on the basis of those facts. he will say that because of the presence or absence of a fact before that court, its decision was not relevant to the decision making in this case. The second is to explain how the law may have been incorrectly or mistakenly applied or applied in a different area of law, which was not the area of law in the case before him, and so was not relevant. Now, towards the end of that section, where Lord Atkin is reviewing the supposedly negative authorities, he deals with what is perhaps the most problematic case as far as he sees. It is a case where the facts are close to the facts before him in Donoghue versus Stevenson. And after admitting some difficulty in trying to understand what the judges were saying, which, as an aside, is quite heartening because all of us have been in those situations where we simply cannot understand a judgment. Lord Atkin said that there are several problems with the judgment, but most importantly, that A, the judges in that case perhaps decided that on the basis of contract law and not negligence, and B, that in any event, they didn't deal with the kind of general principles that he's talking about. Finally, Lord Atkin reviews the judgments from the courts below. Remember, this is a House of Lords judgment. The case would have been heard several times over at the courts below before being heard in appeal at the House of Lords. He says that these judgments, by seeking to confine the law to rigid and exclusive categories, and not by giving sufficient attention to the general principle which governs the whole law of negligence and the duty owed to those who would be immediately injured by a lack of care. So once he has noted that, he looks at a case that was dealt with in those previous judgments. It is one that talks about the category of dangerous items or items that are dangerous unto themselves, and the way in which the courts have held that there was a duty owed in respect of those kinds of things. In fact, he finds that such a distinction is completely unnecessary and perhaps wrong. There's no need to create a special category of items that are dangerous. And he then goes on to find that there should be a duty in relation to perhaps all things. He also quite clearly confirms that a duty of care can and does exist in the absence of contract. Many of the judgments that he has referred to throughout this judgment have dealt with whether there existed a contractual relationship between the parties. Lord Atkin says quite clearly that there is a duty of care even in the absence of a contractual relationship. The final thing that I wish to point out about the judgment is the use of cases from other jurisdictions. In one of the last paragraphs, Lord Atkin has looked at the US law in this matter, and he says, "The mouse had emerged from the ginger beer bottle in the United States before it appeared in Scotland, but there it brought a liability upon the manufacturer." So, he has reviewed all the English law that he finds relevant from his research to come to the conclusion that a duty of care exists in this case even in the absence of any contractual relationship, and even in the absence of any need to classify a good as dangerous. And then he looks across the ocean to the US, where he finds that they have already come to the same conclusion that he's coming to in this judgment. That provided further support for his argument. Here you can learn about using cases from around the common law world to support the arguments in your cases. So let's look at how he finishes the judgment. He affirms the proposition that by Scots and English law alike, a manufacturer of products which he sells in such a form as to show that he intends them to reach the ultimate consumer in the form in which they left him, with no reasonable possibility of intermediate examination, and with the knowledge that the absence of reasonable care in the preparation or putting up of the products will result in an injury to the consumer's life or property, owes a duty to the consumer to take that reasonable care. It is a proposition which I'd venture to say no one in Scotland or England who is not a lawyer would for one moment doubt. It will be an advantage to make it clear that the law in this matter, as in most others, is in accordance with sound common sense. And he allows the appeal. Now, 2 other lords in this particular judgment agreed with him, and 2 others dissented. But at the end of the day, Lord Atkin's judgment carried the day. His formulation of negligence and the general nature of the duty of care is what we still have around the common law world. I hope that this review of the judgment and just working through the different sections has helped you see the many ways of using case law to support a legal argument. Lord Atkin reviewed the current state of the law, used the cases that supported his proposition to make an argument, reviewed the cases that went against his proposition and either dismissed or distinguished them, and also looked outside of his own jurisdiction for support. We hope that you will be using some of these techniques in your own work soon. Thank you for watching.